What's up, guys? Welcome. Welcome to Lawsplaining the Interwebs, and let me get the chat updated. Everything, no one should give me access to any sort of computer or technology. I should have to do everything by smoke signal. I'm sure that would be cultural appropriation or whatever, but that's what should happen. I don't know why the frame was freezed on the other one. Frozen. I don't know what it was. Focus. Oh my God. I'm gonna kill everything. So I am trying new software. I apologize profusely. From the bottom of my heart, I apologize. I'm trying to stream to both YouTube and stream.me, which I think I have actually accomplished. They're both running. I can see them now. All I need now is the Stream Me chat pulled up just so I can follow along there as well. I will have to work on getting that onto this OBS thing so that the Stream Me... Whoops. I mean, I could just put it over here. There you go. But I don't want to keep it there. So, we have that running. Everything in my life is a work in progress. Okay. So guys, all day, I've been wondering what I'm going to do tonight because, I wasn't sure. I've got a couple different things that are to cover. There's some updates, very mild updates in Hambly versus Loader, Russell Greer, and diversity in comics. Okay, very, very minor updates. I want to just make sure. I think I've mentioned most of these before, actually, but I want to make sure everybody's on the same page with that. All right, so we're going to talk about that a little bit. But breaking news. Apparently, Sargon's Patreon has been shut down. Sargon of Akkad has been thrown off of Patreon. So, what do we make of that? What do we make of Sargon's Patreon being taken down? I don't know. I know there are people who will be very tempted to be happy about that. I'm not. I don't want anyone's Patreon taken down, ever. I don't want people deplatformed from anything. So I'm not happy about that. Now, is there some sort of cosmic justice demon or whatever at work? Maybe. Some people would argue that he had it coming. Again, that's not my argument, but I know there are people out there. I know there are people who watch this show, who watch other shows that I may appear on, who are not the biggest fans of Sargon, and specifically because of his recent activity and his drama, mostly. I shouldn't call it his recent activity. His recent drama with the kill stream and other people in kind of the internet creator community. I don't know, but he's been going through some issues. There's allegations of attempts to deplatform and interfere with people's work, with people's stuff. And again, I don't know. So before anyone spazzes out on me in the in the chat, because the last time I mentioned something about Sargon, a couple people went off on me for quite a while. I'm not saying that that's the case. I'm saying there are people who would argue that, okay? And so some people would say that there's some sort of justice or karma or something going on. He has it coming. I don't know. Not up to me. I don't want anyone deplatformed. But this is major stuff. He's a large Patreon, or he had a large Patreon. It's probably a big source of income for him. And to have that gone is probably devastating. And yeah, I don't know why. I don't understand from Patreon's perspective, why are they taking down Sargon of Akkad? Uh, he's mildly edgy. It'd be like taking down me, right? Like I'm not overly controversial. I don't think Sargon of Akkad is a white supremacist or something like that. He's like just a boring British nationalist. Okay, it's fine. Why are you taking him down? They might be increasing Sargon's credibility by making him out to be a bigger threat than he ever was. Sargon has very interesting points. I've watched his channel for a couple years now. I like generally a lot of his content. He's fine to me. He's fine. I don't see why he's being taken down in the slightest. It's crazy. This idea that if we don't like someone, we have to remove their ability to speak to the world, because you'll never hear from Carl Benjamin if Carl Benjamin can't be on a platform like YouTube, for example. And how long can he sustain without a Patreon? How long can you keep doing this type of stuff when your income is constantly being attacked? I don't know. So you won't hear from a guy like that. You won't get that opinion into the world. He will be effectively shut out from giving his opinion if we keep up deplatforming. Now, right now, he still, as far as I know, has the ability to speak on YouTube, which has probably the largest reach of any major speaking platform that there is. So as long as he's on YouTube, he does have the ability to communicate. But if Patreon is kicking him off, well, it'll be very interesting to see the next couple days and what happens with his other channels. Because as we've seen with other creators, with other companies, and with other personalities, it's not ever just the one channel or the one medium that gets taken out, right? It's the funding, then it's the platforms. Funding and then the platforms. So we'll see what happens to Sargon. Hey, Carl, Sargon, Mr. Benjamin, whatever I need to call you. Let me say this. This is your fault because you said on the Dick Show that you would come on my show, and then you didn't respond to my Discord direct messages, and you didn't respond to my emails. So that's why this happened. Dark magic in the Rekieta Law dungeon has forced you off of Patreon just because you didn't come on my show when you said you would. And that was rude. That was very rude of you. So open invite still. I think, now you've got something else to talk about too. But I didn't even want to really talk about drama with you that much. I wanted to talk about your involvement in politics, how you've gone from being a guy yelling at the internet into someone who's decided to try and make effective change. Whether or not you're effective is surely open to debate, but someone who's at least trying to do something more than just speak into a camera. I think that's very interesting, and I thought we'd have a good interview. I don't know why you chose to go on other shows where you got like made fun of or ripped apart. I wouldn't ever treat you like that. So again, weird choice, man. Weird choice, but I get it. You shouldn't be deplatformed. No one should. Can I check on his case versus Aquila and see where it's at? I can. We'll see. To understand why they take people down, you have to forget about logic. That's true. Berserker Bauer says, you've gone from boomer to boomist. Yes, I have. Thank you. Thank you for reminding me of that. Probably not my name. I am actually a little salty about it. Yes, because I try, all you have to say to me if I ask you to come on my show is, you know what? Not really for me. Fine. I don't care. I've asked plenty of people to come on the show who have said no. But when you say yes, and then you just ignore the attempts, and of course, I don't want to look like a turd. Like, I don't want to just keep sending emails over and over. So, but once you say yes, at least have the decency to respond and say, you know what, I've changed my mind or something like that. You're not going to hurt my feelings. Yeah, I am a little salty because if someone says they're going to go on a show, then they should go on a show. And to the people out there who have asked me to be on their show, I will still do it. And if I am deficient in responding to you, please don't hesitate to let me know. I know there's at least one email I have to answer. I've just been very busy with moving into the new place and with getting ready for a trip. So forgive me. It's not personal. And feel free to hit me up anytime, and I will get back to you. Robert Hancock says, Patreon will rise. Will it? I don't know. Wasn't Patreon created by Cody Wilson? Cody Wilson, the now forever sex offender who tried to murder the entire earth with 3D guns. The sideburns are me being lazy, buddy. Me being lazy. I can't pull up the clip. No, he said sure. Buying feet pics. Don't you dare. Don't you dare. I was there. I'm like 99% sure he said, sure, I'll come on your show. Can you pull up the clip? Honestly, after the first 10 minutes of this stream, where I think I ran like 19 streams to stream me, do you think I can honestly pull up a clip on the fly? No. I need like hours of planning and a guide and a Sherpa to help me pull up a clip of some other show. Okay. What happened to Cody? That's a good question. That's a good question. I don't know. I will look, but the problem with Cody's case is he's being prosecuted in Texas and in Austin. And so getting the documents from Austin, Texas on a state case, and it's not easy. It's not like federal court. Federal court, Pacer's there. It's stupid that you have to pay for it, but it's there. I can pull up the documents. Like, for example, what do we got? Hold on, I'm looking for the where did it go? Did I not get it yet? Hold on one second. Let me pull up this. Whoa. Why is this zoomed in? Oh yeah, so the motion to conduct jurisdictional discovery. Oh yeah, did I not download this? Here we go. No, I didn't. How interesting. Let's hold on. Let me get it. Terrible at this. But see, Pacer allows me to do this on the fly. Like I'm getting this document right now. Very easy to get this. Let's see. All right. And now I just have to do this. I know this is riveting. This is riveting television, watching me fumble through all of this stuff. There we go. So in just a matter of like 25 minutes of boomer viewing, I can pull up a document from Pacer. Cody Wilson's documents are a lot harder to get to because I think I actually have to buy them from Austin, and I don't know if they'll even give them to me because it's an ongoing case. So that said, is there a chat? Someone said there's a restream chat also. I don't know how that works. Yeah. What do we got? I'm flipping through like 1,000 windows at a time here. So here we've got diversity in comics motion. I'm still just blown away by the fact that Sargon actually got removed. That's just crazy. Like, why? Why would he do that? Or why would they do that? Anyway, there's a couple chats. Let's go through, and then let's look into this Meyer case. Does anybody know? Like, I mean, I'm sure Patreon hasn't said anything about it. They just remove him. I don't suppose he's given any indication about why he's been taken down. Brian Seam, I'll get you a case number. Can you DM me on Twitter so I can get you that information? Okay. Yeah, my Zephael, my phone got royally hosed up in the move, and I think I have to change phone numbers. So that's nice. That's good for businesses, right? To have it change. But yes. That's a fun problem I'm dealing with. But I don't really feel like dealing with it till I get back. Cuz I'm out. And yeah. So, yes, email is the best way right now. Oh my goodness. Okay, so all right. Christopher Nicholson says Knoxvillian here. See you at the fight. See you at the fight, buddy. Hopefully. Again, I'm mostly confirmed. I just have to get the plane booked. Landon Mackinjames says, "Oh boy, Nick, I'm off today. I'm drunk too, buddy. Good job." I'm not drunk yet. That's the worst part. I think if I were actually intoxicated, I would more competently go through this. But yeah, who knows? Who knows with Sargon? It's crazy. Sorry, I'm responding. I should respond to this specifically. Buying Feet Pick says, if Carl of Applebee's has been taken down, what are the odds of Dick getting slapped down too? 100%. I think inevitably Dick will be kicked off of Patreon. I think it's a matter of time. But that's like the function of Dick Masterson is consistently moving towards chaos. And he's been stable on Patreon against the odds for so long that I think inevitably he'll have to just go. But we'll see. I hope not. I hope not. Dick deserves every dollar of Patreon that he gets. And there's no reason to kick him off. Screaming Dizbuster says Ralph Retort speculated Sargon was taken down for doing a speech to the Proud Boys. So maybe that's the case. Apparently who you talk to will now get you thrown off of making money. I guess. The stone glass is at my old house still. I haven't moved all the whiskey stuff because it's fragile. So most of my liquor and glassware is over there because it's a pain to move everything. We've been moving the big stuff so far. All right, let's get into this because otherwise I'm going to sit and yammer on for a long time. And we can do that afterwards. Now that things are kind of settled down. Yeah, I'll retweet that Sargon thing. That's wild. That's wild. But let's get on to some of these cases and talk about where they are. So we've got diversity in comics first. I feel like I talked about this, but I can't find that I actually downloaded the document. So we're going to talk about it real quick. This is an unopposed motion to conduct jurisdictional discovery. This was filed on the 28th of November. It was granted on the 29th of November. It was unopposed, so that makes perfect sense. So this is discovery to determine whether or not Texas, Western District of Texas, has appropriate jurisdiction over Mark Wade. Specifically, they will be looking at the nature of the involvement in the transaction. The transaction being the alleged tortious interference of Richard Meyer's contract with Antarctic Press, the publishing contract with Antarctic Press. Okay, which again, if you some people keep conflating these two things. The publishing agreement with Antarctic Press is separate from his Indiegogo or GoFund, I think Indiegogo campaign to fund Jawbreakers. The Indiegogo funding of Jawbreakers was done. There's that money has, to my understanding, been processed or whatever and distributed, or at least a large portion of it has done that. And now Richard Meyer is supposed to fulfill that order. So everybody who ordered on Indiegogo, he was already dealing with that printing in a specific way and distributing it in a specific way. The Antarctic Press contract was for a follow-up version of Jawbreakers Lost Souls that would be printed out with a variant cover, if I understand correctly, and distributed through the traditional channels via Diamond Publishing or whatever, or not publishing, but Diamond distribution, and they would put the Jawbreakers Lost Souls into comic shops through the traditional sort of means. Okay, so they're two separate things. People keep mistaking that. So whatever happened with his Indiegogo, that has nothing to do with it. That's not what Mark Wade is accused of interfering with. He's accused of interfering with the contract with Antarctic Press. That entire thing takes place in Texas. So what they're going to do is conduct jurisdictional discovery. That means that they're going to ask for documents and records related to that transaction. Also, the other transaction would be, because they'll be treated separately as separate claims, and Texas could have jurisdiction over one claim and not the other. The other one would be the defamatory statements that Mark Wade is alleged to have made about Zach Meyer. Okay? Or Richard Meyer, your boy Zach. So those two things. So they'll be asking for documentation and records related to those two events. All right? Some of those documentation and records, they'll probably request phone records of Mark Wade. You know, what phone did you use to make the phone call to Texas? Did you dial a Texas area code? Maybe it wasn't a Texas area code. That'd be a really interesting twist if he got a cell phone number for like New Mexico, and that person, the cell phone for whatever reason was just never changed, so he didn't know he was calling Texas or something like that. So they'll be asking for records for the outgoing and the incoming call. They'll look to see if there are any other calls from that number. They'll request any voice messages or emails that may have been exchanged between Mark Wade and Antarctic Press. They'll ask for all that type of stuff. Also, they'll be requesting documents and records of any business-related transactions that Mark Wade had in the state of Texas, because they have to find out. Well, we can just read it. Here we go. So the jurisdictional discovery, Meyer requests that he be allowed to conduct the following discovery. So this is what they're asking. No more than 7 document requests to Wade seeking information about his contacts with Texas relating to Wade and Antarctic Press, including text messages, phone records, social media posts, emails, public statements, and other Texas-related communications. So they'll have 7 opportunities to request documents. Typically, a document request will have lots of subsections, right? So it's all of the documents related to this, including blah, 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 blah. A bunch of bullet points, emails about this, emails about that. So that's the 7 document requests. That's interesting. Am I a fan of the Star Wars movies? Not really. Not big. All right. I did already read this one. I know. I'm not going to read the full thing. I just want to make sure if anybody missed this that we get updated. And I'm going to talk about it very briefly and then we're going to move on. It's not a long document, but I'm not reading the whole thing. So next is submit no more than 3 interrogatories requesting Wade to identify his contacts with the state of Texas over the last 2 years, as well as to identify persons in Texas with whom Wade communicated, if any, regarding Meyer and the substance of those communications. So the interrogatory request is going to be, list every person you spoke to in relation to comics in Texas, or it'll be worded more specifically than that. But it'll be Wade having to, under oath, answer questions about his business arrangements with Texas. Very, very important over the last 2 years. It's going to include conventions. It's going to include signings that are related or unrelated to conventions. It'll be appearances, speeches, anything that he's done in Texas, any video casting that he did to a conference in Texas, like say he was in California, but remotely connected to some happening in Texas and gave a speech or something like that. All of that would be included. Subpoena documents from non-party Antarctic Press relating to Meyer, Wade, and Meyer's comic book. So they'll ask Antarctic Press for basically every piece of information relating to this subject. And finally, depose the 2 owners of Antarctic Press for no more than 3 hours each to determine the nature and extent of their communications with Wade and the reasons for canceling the contract, if any. And then depose Mark Wade in California or in Texas for no more than 3 hours about his activity regarding Antarctic Press and his contacts with Texas. So those depositions will be under oath. They will likely be recorded, either audio and video recorded. I don't think we'll have access to those during the case. If we do, if there's any way I can get my hands on those, I will absolutely show you what I can from those depositions, even if it means cutting them down and condensing them. If there's any way for those to be public, and depositions typically are public in some cases, if they are public and available, I will get them. We'll go through them. So that's where we are right now. All of the extensions requested have been granted, including this jurisdictional discovery one. I apologize if you saw the stream in which I read through this before, but again, this is kind of an update stream, making sure we know where we are with this case. The jurisdictional discovery will be completed within 90 days of authorization. It was authorized on 11/29. So that means by the end of February, we will have the jurisdictional discovery complete. Hopefully we'll start getting some things to trickle in before then, but probably not too much. I would think if they get some good discovery information, they're going to be using that to work on negotiating a settlement. So, and make no mistake, this case going beyond settlement is really dumb for Mark Wade. And the fact that he hasn't settled it already and is just dumping money into attorneys is beyond me. Paying for this is going to be massively expensive. Like this request, just think about this way. So Mark Zaid, I think it's a meme. I think that his hourly rate is $750 an hour. I don't think it actually is. I think he thinks he's trolling and that it's funny or something. But he's shown over and over that he doesn't understand how to be funny or how to troll or to have a personality at all. So we'll assume, let's just drop his hourly rate to $500 an hour as opposed to $750, and even $500 for the numbers. Assuming you've got Zaid doing any of the depositions, which I doubt he will, but let's just say it's Zaid or someone at $500 an hour. You've got 9 hours of deposition listed right here. That's expensive. That's if you've just got one person doing that deposition. You have to pay other expenses too. You might have another attorney present doing the deposition. You might have to hire a videographer to record the deposition. You typically do have to hire a transcriber to transcribe the deposition. So, some of that will be borne by Meyer, of course. If he's requesting the depositions, he will be paying the bill for that. If Wade decides to depose Meyer, which is a part of this agreement as well, that Meyer can be deposed for up to 3 hours, Wade will have to pay for that type of stuff. So all of this comes with cost. Responding to document requests, that's just hours of time that get eaten up in attorney's fees. Responding to interrogatories, that means that some attorney has to get on the phone with Wade and go through each of those questions, get truthful answers to the best of their ability, investigate potential objections, do all of that stuff. That has to be done. It costs money. It takes time. So yeah, it's 7 above here in Prior Lake. Is it colder up north? I'm west. I'm not north of you. I'm like straight shot west from Prior Lake. It was about 10 degrees a little bit ago, so it's probably the same. Okay. So that's where we are. Oh, you know what no, never mind. I was going to tweet out the link and then I see that a bunch of people have found it. So that's where we are with Meyer versus Wade. We're probably not going to get much in the way of content on Meyer versus Wade for the next 3 months. It'll be very quiet. And this is the hard part about these cases. At some point, like there's a bunch of stuff that happens at the beginning. There's hype. There's lawyers getting hired. Everybody's making their initial filings. There may be a little bit of a back and forth about something. And then poof, we get to the part where it takes time. Jurisdictional discovery takes time. The rest of discovery is going to take time. But what comes out of this will be really, really interesting. Next. Russell Greer. Should we talk Russell Greer? Russell Greer versus Taylor Swift. Hold on, let me pull this up. I know we have not talked about this one. Here we go. Nope, I think it's on my Google Drive. Just a second. Because, I know I have the Russell Greer order. Yeah, here we are. Let's download this bad boy. Right into Greer. All right. Let's get this guy pulled up. So, if you don't remember, if you guys... Let me just drop a personal note here. If you are not watching the Greer streams with me and Sriracha on why Russell Greer, reading through his book, Why I Sued Taylor Swift. If you're not watching those, you are incorrect. You are incorrect. And I don't have any other way to say it. You should be watching those streams. They're fantastic. And they're not fantastic because of me. Don't mistake my assertion here. They're fantastic because Russell Greer is absolutely insane. So Russell Greer is suing Taylor Swift. You've got to watch those. Unfortunately, I won't be able to do the one that would be scheduled on Wednesday of next week because I won't be streaming this coming week. So I apologize for that. But that being said, Russell Greer attempted to serve Taylor Swift by serving a lawyer that he looked at and said, this lawyer at one time represented Taylor Swift. Certainly I can serve that lawyer. Bzzzt, wrong. You can't serve that lawyer unless they have been specifically authorized to accept service on behalf of their client. In fact, any agent, not just a lawyer, can only accept service with explicit authorization to do so by their principal. So even Taylor Swift's agents who he is contacted by email over and over again. He can't serve them either. They have no duty automatically, despite what Russell Greer thought. They don't have a duty to go ahead and pass on service to Taylor Swift unless she has authorized them to do that. And would you ever do that? No. No, don't authorize an agent to accept service of process for you. Don't make it easier for your opponent to sue you. That is not something you should do. You can't make it harder for them. You can't intentionally like evade service and all that stuff. But if you're a busy person who has several homes and travels across the world all the time, like Taylor Swift, for example, and it's just hard to get a hold of you, well, that's just too bad. That's just too bad. So you have to serve properly, and Russell Greer did not do so. So he filed for default judgment because he thought he had sued her effectively or served her effectively. Taylor Swift had a lawyer come in and appear not accepting service, but appear just in her capacity to respond to the default judgment. Just to respond to the default judgment and say that the service was improper. So then Greer made a motion to have the court force an alternative discovery, and he also had a motion to alternative service, and he also had a motion to reissue the summons for an extension of time to properly serve. And that was granted. The other one was not. The judge here seems about as confused as anyone reading a Russell Greer legal document. So let's take a look at what's going on with that. If Kevin Smith had a heart attack on your set, would you be liable? No. Unless I did something specifically to cause that. Siren Jag says, truthful answers from Wade. There's a better chance of Greer drinking cream of mushroom soup through a straw in Seattle. Oh, that's disgusting. With the deposition. So, he has to give answers under oath. That doesn't necessarily mean they're going to be truthful. People lie under oath all the time. The thing about lying under oath when it's recorded like that is if there's a way to discover the alternative, the truth, the whatever true thing that they lied about, you can use that to impeach them, and it'll be really, really devastating. Also could carry, perjury charges and stuff like that. So we'll see how that goes. Stacey Gardner, why is Greer suing Taylor Swift? In short, because Taylor Swift went to prom with like some kids who asked her, or she would show up at a kid who's like dying of cancer. She would show up at their hospital bed and just kind of cheer them up and say hi. Or if someone like made her a macaroni noodle artwork, she might take an Instagram photo and say, hey, got this from Tracy D. So awesome. Thank you for the art. Right? Like she would do that. Russell Greer wrote a song and tried to send that to Taylor Swift. And since she's a recording artist who's just ripe for lawsuits, she doesn't accept any musical work. Now, Greer asserts that it's not for her to sing or perform this song. It's a gift for her. It's a song that is a gift. And her agent said she can't accept any music, which is a very good policy if you're a famous recording artist with lots of money, because if she made any sort of future song that sounded at all like anything someone sent to her, it'd be a lawsuit city. So she has a policy of not accepting that. Greer is suing for $100 million of damages and then he is also suing to basically stating that she had a duty to warn him that she might not accept his disgusting song gift. Okay. Oh, and he also definitely wants to bang Taylor Swift over and over and over, probably until she's dead and in a garbage bag and buried in the ground, if I had to guess. But he has a fantasy where she listens to his song and then immediately falls in love with him, even though he's hideous both inside and out. That is honestly why he has sued her. And if you don't believe me, I can confirm that when he sued her the first time and failed, he offered a settlement of a dinner date with Taylor Swift. So the settlement be like, oh, we'll just stop this lawsuit thing. Give me dinner with Taylor Swift. He lost that lawsuit too. So he's looks to be some sort of stalker or just mentally unstable person. That's why he's suing Taylor Swift. So, yeah, malicious litigator, probably. And yes, Stacey Gardner, I'm 100% serious. Seriously, I have a playlist of Russell Greer suing Taylor Swift. You got to watch the Why I Sued Taylor Swift live streams with Sriracha. There's now 6 or 7 of them. I think just 6. We've done one chapter at a time. Although 5 was such a long chapter, we had to break that up into 2 parts and do the last part of 5 and the first part of 6 in the most recent stream. Go watch them. They'll blow your mind. They'll blow your mind. All right. So here we go. He's not figuratively punched in the face because getting anything near his face is a drool. It's in the drool splash zone. Okay, so order. This is the order from the judge in response to his motions. The judge will explain the motions. So I'm going to just read through it. It's 6 pages. This won't take too long. It's kind of funny. It's funny to me, and I'll explain what's funny to me as we go through it. Plaintiff Russell G. Greer has filed 3 motions related to the initiation of this case. A motion for default judgment, document number 10. A motion to allow Taylor Swift to be served by substitute service, document number 14. And a motion for the court to reissue a summons for that purpose, document number 13. For the following reasons, Greer's motion for default judgment is denied. The motion to reissue a summons is granted, and the motion for substitution of service is found moot. Background. Greer filed this action on April 25th, 2018, alleging in essence that Swift has failed to warn consumers of her intellectual property, that her public persona is a publicity stunt, that's in quotes because that's his favorite term, and that Greer relied on her misrepresentations to his detriment. Greer seeks a declaratory judgment. Declaratory judgment is the court saying this is wrong. Injunctive relief is the court saying you can't do this anymore, you have to stop. And money damages. That's money. The clerk's office issued a summons for Swift. The summons return, however, shows that it was executed on August 7th, 2018 by a person, quote, designated by law to accept service of process on behalf of Venable LLP. Footnote number 1, it is not apparent from the record where Venable LLP was served. Swift did not answer Greer's complaint or file any other responsive pleading. On September 14th, 2018, Greer moved for default judgment. On the same day, counsel for Swift, who does not list an affiliation with Venable LLP, entered a limited appearance for the purpose of opposing Greer's motion. Counsel argued that Greer's motion must be denied because Greer has served an entity that is not a party to this action and is not authorized to accept service on Swift's behalf. Greer replied that serving Venable was appropriate because its attorneys have represented Swift in other cases and previously accepted service on her behalf. Greer states that he served Venable only after he asked several other alleged representatives of Swift to, quote, waive service by accepting his summons and either received no response or had his process server turned away. It's because they're not going to accept service. And they can't waive service on behalf of Swift, you idiot. Only she could waive service. Brennan Pitts, the lips are actually at my other house. In his motion to reissue the summons, Greer asked the court to issue the summons that will allow him to serve Swift at 2 concerts scheduled to have taken place in Texas on October 5th and October 6th. Can you imagine? His plan was to go to a Taylor Swift concert and somehow serve her legal documents. I'm guessing he was going to ask the court to mandate a backstage pass for him. In his motion for substitution of service, Greer alleges that Swift's authorized representatives have evaded service and that personally serving Swift is impossible. He therefore asked that he be allowed to serve Swift through the security detail at these concerts. Like, just think about it. Going up to some private security guard, like some giant 290-pound bouncer sitting there, arms folded, and like Russell Greer walks up, "Excuse me, do you accept service on behalf of Taylor Swift?" Like, can you imagine? What? Oh, I hope they throw him into the sun. Legal standard. Without proper service of process, consent, waiver, or forfeiture, a court may not exercise personal jurisdiction over a named defendant. That's King versus Taylor, citing Murphy Brothers versus McKetty Pipe Stringing Incorporated. Hoosier Highway says Russell Greer and Chris Chan need to cross paths. They need to breed, I think. Tillip, I'm my own neighbor, Rekieta. Yeah, Nick, I'm my own neighbor, Rekieta. Yes. Yes. It is a, quote, bedrock principle that a defendant is not obliged to engage in civil litigation unless the defendant is properly notified of the action and brought under the court's authority, i.e. personal jurisdiction, by formal service of process. That's Arthur versus Litton Loan Servicing. And in the absence of personal jurisdiction, a federal court is, quote, powerless to proceed to an adjudication, citing King again. Federal Rule of Civil Procedure 4 provides that when serving an individual within a judicial district of the United States, a party may follow state law for service in the state where the court is located or service is made. Alternatively, under the federal rule, a party may personally deliver a copy of the summons and complaint, leave a copy of the summons and complaint at the individual's, quote, dwelling or usual place of abode with someone of suitable age and discretion who resides there, or deliver a copy of summons and complaint, quote, to an agent authorized by appointment or by law to receive service of process. That's Tennessee Rule of Civil Procedure 4.04 sub 1, which closely resembles the federal rule. Allows service of an individual personally or, quote, if he or she evades or attempts to evade service by leaving a copy at the person's dwelling or delivering copies to an authorized agent. Is Greer a big guy? I don't think so. He's long overdue for a trip to Greenland, I think, at this point. Let's see. Although the Tennessee rule requires a finding that the person has evaded service as a prerequisite to service through an agent, the federal rule does not. Because Rule 4E2, that's a federal rule, is procedural, it applies in a diversity action. That's Hannah versus Plumer. This is a diversity jurisdiction case. So you have federal rules of civil procedure. There are certain actions where the federal court would have to apply local rules and not apply federal rules. In procedural rules, they apply when there is diversity jurisdiction. So if it was original jurisdiction, it would also apply. But that's where you get interesting cases. So in a diversity action, procedural rules of the federal government apply as well. So a plaintiff need only comply with Tennessee rule if it is invoking Rule 4E1. Okay. Federal Rule of Civil Procedure 55 establishes a two-step process by which a plaintiff may obtain a default judgment against a party who fails to defend against his claims. If a party fails to answer or respond to a complaint within the prescribed period of time, and that failure is shown by affidavit or otherwise, the clerk of court may enter a default under Rule 55A. Only after default has been entered may the plaintiff move for default judgment. A party against whom default has been entered may move to have the default set aside for good cause. A party against whom default judgment has been entered may move to have it set aside under Federal Rule of Civil Procedure 60B. It is important to distinguish between an entry of default and a default judgment because of the difference in these standards. Guys, the best part was that on the day that the time lapsed, the 21-day summons lapsed, and Taylor Swift hadn't responded, Russell Greer posted she defaulted, like best day of my life or whatever it was. He was so happy. He was so happy. This idiot thought he just won $100 million from Taylor Swift. That was his, it's like, yes, I got her. I got her. Taylor Swift, who has lawyers all over the world. I figured it out and I won because she just forgot to respond. We got to get an Olive Garden to Greenland. Actually, Olive Garden should definitely go to Greenland. Analysis. As an initial matter, the dates of the concerts at which Greer hoped to serve Swift have now passed. This renders his motions for a reissued summons and substitute service technically moot. However, because Greer indicates an intent to attempt to serve Swift at other future events, the court will address his motions on their merits. So he's going to try. He's going to get to a concert, and he's going to try. Greer states that he moves for entry of default judgment by the court under Rule 55b-2. However, prior to obtaining a default judgment under either Rule 55b-1 or 55b-2, there must be an entry of default as provided by Rule 55a. That's Heard versus Caruso. Because Greer has not yet sought entry of default from the clerk, it is improper for him to move for an entry of default judgment. The motion must be denied on that ground alone. However, even construing Greer's motion as one for entry of default, Swift's response in opposition shows that she has not yet been properly served. Greer argues that service on Venable is proper service on Swift because Venable has served as her counsel in other actions, and the only proof Greer offers is of that fact. But proof of an attorney-client relationship, even when in the action in question, is not sufficient to show that service through the attorney is proper. So even if Venable is specifically representing Taylor Swift in this action, which so far they are not, at least publicly, but she hasn't been served, so who would know? They don't have to authorize acceptance of service through Venable. Now, some courts, once an appearance has been made, will require you to sign up for electronic service. Actually, many courts across the nation do this. You have to sign up for electronic service to counsel or to yourself if you're not represented by counsel, and that's just how it goes. That's a court rule, and once that's established, you've got an attorney appearing for you. They probably should be accepting service on your behalf at that point. But if the court does not require that, it's not necessary under the law. Just maybe a jurisdictional rule. The record must show that the attorney exercised authority beyond the attorney-client relationship, including the power to accept service. That's United States versus Ziegler Bolton Parts Company. At a minimum, long-standing precedent advises that, quote, the authority of an attorney commences with his retainer. He cannot, while acting generally as an attorney, accept service of process which commences the action without any authority to do so from his principal. That's from Stone versus Bank of Commerce from 1899. And says, and Schwartz versus Thomas, which says, attorney has no power to make any agreement for his client before a suit has been commenced or before he has been retained to commence one. Greer alleges only a past relationship between Swift and Venable, and even if he alleged that Venable represented Swift in this action, that alone would not be sufficient to establish Venable as a proper agent for service. Thus, even construing Greer's motion for default judgment as a motion for entry of default, it must be denied. Greer also moves to have a summons for Swift reissued and to serve Swift by substitute service. The second motion is unnecessary. Rule 4E2C allows service by delivery, quote, to an agent authorized by appointment or by law to receive service of process. No leave of court is required, and Greer's motion is found moot. See, Russell thought he was going to trick the court into forcing some agent of Taylor Swift to accept service. That's why this is funny. He thought he had found a way around. He thought the court could do that. Court's like, you know what? Or Greer's like, you know what? I'm going to force the court to make Jay Shouties accept my service of process and give that to Taylor Swift. That's what he thought he was going to do. Not going to happen. You can give it, there's already in the rule to deliver it to an agent who's authorized to accept service. Landoname says, I kid you not. Once my dad said, I bet Taylor Swift eats buttholes. I sat there as a 16-year-old, struggling to understand. All I know is he hates her. Oh, so he must not be into eating buttholes, apparently. Okay, Greer's motion to reissue a subpoena, which is not actually, that's a typo. It's a summons, not a subpoena, faces a preliminary procedural hurdle. More than 90 days have passed without Swift being served since Greer filed his complaint on April 25th. The court must therefore determine whether it should recommend dismissal of Greer's action without prejudice or order that service be made within a specified period of time. In making this determination with regard to pro se litigants like Greer, the court must construe Rule 4M leniently. Footnote 2. Greer also states that personal service of Swift would be very costly and that he should not be required to serve Swift because he cannot afford to do so. Rule 4 allows service by the U.S. Marshal when a plaintiff appears in forma pauperis. That means in the form of a pauper, right? As a poor. Federal Rule of Civil Procedure 4C3. However, Greer's motion to proceed in that status has been denied. It's too expensive for me to sue Taylor Swift, so the court should do it for me. He says it's too expensive. There's a way to get it done. We denied that way. Suck it, Greer. Sorry, that's funny. Funny to me. With that standard in mind, the court will order Greer to serve Swift in compliance with Rule 4 within 60 days of the date of this order. Conclusion. For these reasons, Greer's motion for default judgment is denied. Greer's motion for substitution of service is found moot. The motion to reissue a summons is granted. Greer is ordered to complete service in compliance with Rule 4 within 60 days of the date of this order. By January 15th, 2019, Greer is forewarned that failure to obtain service by that date will likely result in a recommendation that this case be dismissed without prejudice. So basically, Greer would lose his filing fee. Good job. Good job, Greer. Landoname says, no, Nick, I'm serious. He had just watched the Country Music Awards. I was in high school. He literally said that with so much aggression. I believed you. I'm just saying that some people would say, I bet Taylor Swift eats buttholes in like an endearing or hopeful way. And he said it in a hateful way. So that's interesting. Like if Bunty, for example, if Bunty were to say, man, I bet Taylor Swift eats buttholes, you'd know that he would be hopeful in that action, right? Like that would be a good thing because Bunty apparently is into eating buttholes, I guess. So you guys can mull that over all you want. He thinks eating booty is mealy. He's suing Taylor Swift for $100 million. Sadomasochist. So that's that. That's where we are in Greer's case. We will have an answer on this by January 15th, 2019. Just remember, folks, Greer's plan, because service of Taylor Swift is too expensive. It's too expensive. His plan is to come across a ticket to a Taylor Swift show that will get him close enough to a security guard to try and hand him the documents. So we're talking a floor ticket to a Taylor Swift show, $500, $600, $700, maybe. If you're lucky, if you can even get one, because usually you have to wait in line or get on some sort of list or something like that. That's his plan. His plan is to make service of process to Taylor Swift much more expensive. Greer, Look at the Tennessee rules. There's probably another way. If I had to guess, I don't know, but there's probably a different way to serve her. Maybe. Look at the federal and the Tennessee rules. I don't actually know, but there may be some alternative service that you could try. I don't want to help you at all, so go look at them. Come back to me, Greer. Come back to me when you get it. Please come on my show. I want nothing more than you to read a chapter of your book with me. Please do that, Russell. If you see this, you're welcome on my show. I will not make fun of you on that episode, unless you're okay with that. I'll make fun of you now, but in an interview with you, I would treat you with respect. Come on my show. Talk about this. Talk about how you got boned out of suing Taylor Swift twice, and how unfair it is. Because I'm gonna be honest with you, suing someone like Taylor Swift is actually unfair for a normal human being. It's really, really hard, and I can sympathize with you and empathize with your frustration over trying to sue someone who has the money to not want to be sued, and to do it without actively evading anything, but just by making it really difficult for someone to approach them and deliver a suit, because she's surrounded by security and an entourage. How are you going to get papers into her hands if her agents aren't authorized to accept service? I'm with it. Come talk about it. Come talk about it with me on the show. I guarantee that will be a blowout of a show. People will, we will have an absurd amount of viewers. Open invitation, Russell. Open invitation. Of course, there's a way to serve her that he would like. Roasted, fried, baked, barbecued in the ground at a loo. Now, Nico Persianian. I don't know how to pronounce that, but hopefully that was right. Nico. I would still have Mark Zaid on my show. And I would... Ooh, that would be a great show. That would be a great show. Mark Zaid. When you eventually have to watch this because it involves diversity in comics tangentially, I would love to have you on the show. You can call me an idiot all you want, friend. All you want. I hold no malice towards you. And we'll see how things go for your case. We can wait till the case is over if you want. But that invitation will remain open. Even if you and your side win, I will have you on and you can gloat at me all day. All day. Because I still think you'd be interesting to talk to. Even though you're kind of not very funny. But that's okay. What's on your bookshelf behind you? Bunch of Warhammer books, buddy. Oh, yeah. You guys probably couldn't see them as well because at my other place, I had to stream in 720 because I had a slower upload speed. Yeah, it's Warhammer. I'm a little bit of a nerd. That's to my knowledge, every special edition printing that Black Library has done is on that shelf. Well, actually, there's a couple more in a box down there that I haven't unpacked. But yeah, that's what that is. So. Taylor Swift, also very welcome on the show anytime. I'm a huge fan. Unironically. Love your work. Thank you. So, but this is actually not a date because I wouldn't go to dinner with you. But no, you are welcome to come on the show and laugh at Russell Greer with me. That'd be funny. Next, what do we have next? Oh, Hambly versus Loader. This is the quartering, the quarter pounder, the quarter pounded, whatever your perspective is on him. Jeremy Hambly, Magic the Gathering. So it's the quartering. What's his other? Unsleeved Media. I don't even know what that means. Unsleeved Media. Let's take a brief look at this. This is a couple pages. Yeah, there are a couple people on Stream Me. I don't have the chat pulled up on the video. I'm going to work on incorporating that, who've just joined and are talking about Sargon getting banned from Patreon. Once we go through this Hambly versus Loader update, I will talk a little bit more about the Sargon deplatforming, and we'll talk about deplatforming in general. So yeah, if you guys are interested in talking about that, feel free to start throwing some stuff in the chat. If you have any new information, we'll talk about that. Let me get this document downloaded real quick. Hambly. Let's see. Pro Hawk Beach. So, speaking of Mark Zaid, okay? Speaking of Mark Zaid. Oh, real quick. Keck7Go says, speaking of Warhammer, when is His Grace going to come down from his throne of money and holiday trips to play with us plebs? Also, Denver versus Georgia and Patreon. Remember Patreon. Remember the Patreon that dismembered Sargon of Akkad. Is that the right rhyme? I don't think so. I would love to play some Warhammer, or some video games or whatever. Maybe after the stream, I'll play a little. Would that be okay, Keck? Speaking of that, it's Keck's ongoing mission to get me to shill myself better. I'm very bad at it. So, lawsplaining, patreon.com/lawsplaining. The $5 and up levels get you access to the Discord. And part of that is I will occasionally, although I've been very bad at it lately, play various video games along with the patrons who are in the Discord, and we can talk on there and stuff like that. Other than that, there's a live chat every Wednesday that occurs, which is just a hangout with the Discord. And the Discord is only for patrons. So the advantage of that is that we don't have a ton, like a spammy Discord at all. It's just people who are invested in the show. We don't talk about the show. Like, we talk about topics and stuff like that, and then whatever else, of course. But it kind of keeps the chatter down in Discord. It makes it actually able to be followed. So there you go. That's that. And Keck, remind me in Discord after the show to live up to my end of the bargain and play some video games, because I want to. I haven't played any games since I played with you. We played Divinity 2 the other day, and that's the last video game I've played in the meanwhile. I'm just like so flippin' busy. So anyways, Black Goat, I can't say that on YouTube. But at some point, I will get the Stream Me chat linked up on the screen so you can tell them what you think of them happily. So, and then Landanime says, shill more time for anime, Patreon/Asterios. And Landanime, I've arranged, this is the last thing before Hambly versus Loader. I've arranged another guest to, what is it? To join us on our Weeb stream, that I will hopefully have you and Anime Outsiders, and then my buddy who is, where is it? He runs an anime podcast you may have heard of called Anime Summit. Anime Summit. Long-term personal friend of mine. He was just listed on Ranker, on some Ranker list. as the best anime podcast you should be listening to. Number 1 on the list of 12. So if you've never heard of Anime Summit, go check them out. But I will have him. I'm good friends. I will have him on stream with us, and that will be a joyous time. I think he will be perfect for the Weeb stream. Like I said, we've been friends for a very long time, and that'll be a blast. So, sorry. Let's see. Back to Hambly versus Loader. Now, this is the first filing. I want to point this out. This is the first filing of Loader's attorney in Hambly versus Loader. It's the first one. Notice what it is. Motion to appear, pro hoc vice. It's really, really uncommon for a cuck attorney in a different jurisdiction to hire counsel and have them file and not mention the other attorney appearing pro hoc vice. It's really, really uncommon for that. In fact, we're covering several cases right now that have pro hoc vice counsel. And always, if the first filing that they do is not a motion to appear pro hoc vice, it's listed on the document that is filed first that there in the caption, pending pro hoc vice approval. All of them, except one. Except one. You stupid liar. You liar. And you can still come on my show, but I'm going to call you a liar when you come on my show. I've called you a liar 100 times now, and I'll do it again. Because, again, you attacked my credibility because of your lie, you giant frizzy-haired cuck. And you can eat all of the buttholes in the world for all I care. Catch fire, good sir. And also, please come on my show when you lose this case. Hambly versus Loader. So this is Loader's attorney, Stephanie Renee Loshing, is requesting entry of an order to appear pro hoc vice. I'm not going to read through it. This is the interesting part of this, and the quartering, quarter pounder, quarter pounded, unsleeved media. I guess that means he's not wearing sleeves while he's playing Magic, because a sleeve would conceal a Magic card. Someone mentioned that in the chat. Sketch Therapy mentioned that. A couple other people. Or Siren Jag says taking protective sleeve off a Magic the Gathering card. Whatever it may be. It certainly doesn't mean he rolled up his sleeves to throw bombs with his fists, because that didn't happen. Either way. So Matt Loader, he's the quarter pounder. Jeremy Hambly being the quarter pounded. And I really don't have anything against Jeremy at all. I just think those nicknames are funny. Stephanie Loshing here's what's interesting. Stephanie is a Wisconsin attorney. Jeremy is in Wisconsin. This case happened in Indiana. The attack happened in Indiana. The beating happened in Indiana. Matt Loader is not a resident of Wisconsin, but Matt Loader has hired a Wisconsin attorney for the Indiana case. And my understanding is that they are requesting venue to be in Wisconsin. Very, very strange. That's where Hambly is a resident of Wisconsin. So they're requesting Wisconsin to take over the venue of the case. I believe the legal jurisdiction would still be in Indiana. They would be applying the rules of the District Court of Indiana. They would be applying Indiana state law to this. They would not be applying Wisconsin law. I have no idea what the angle is on hiring a Wisconsin attorney in this case and then making it more convenient for Jeremy to prosecute the case. Doesn't make any sense to me strategically. Maybe Matt Loader is dumb and is hiring an attorney in Wisconsin because he thinks he has to because Jeremy lives there. Maybe that's his plan. I honestly don't know. Maybe there's something that this attorney told him that knows something about Wisconsin venue or a Wisconsin judge that thinks that this will be advantageous to try in Wisconsin. But all of common reasoning, all of common legal reasoning goes against Wisconsin Wisconsin as the appropriate venue. Wisconsin, in the brain of the founders, Wisconsin would be motivated to defend Hambly over Loader because Hambly is a Wisconsin resident, so they would have a bias towards protecting their residents, especially from being assaulted in another state. That's why you typically couldn't sue Matt Loader in Wisconsin, because if you could, then you would have the advantage. You would have to typically sue Matt Loader either in his state or where the transaction took place, in this case, Indiana. Very strange choice. I don't know what's going on, but according to Hambly, and this is on a stream I was on with him and Richard Meyer and on Ethan Van Sciver's channel, according to Hambly, they're in negotiations to move venue. I honestly don't know what the motivation would be for that. So I can't even speculate on what it would be. It doesn't make any sense. Now, if he just hired her because he had a contact with her and, he was recommended this attorney and she's federally licensed and she can practice, she can be waived in pro hoc vice into that court, and she's just really good at what she does. She handles these types of cases and it's a personal recommendation. Great. Maybe that's the reason. I have no idea. And then maybe they're just moving venue to reduce costs of Loader. Because if she has to travel to Indiana or hire another party, another counsel in Indiana to follow local rules and be a local counsel, that gets way more expensive. So maybe they're just trying to move the venue to Wisconsin to reduce the cost for Loader. But he could have hired counsel in Indiana and gone through the same thing. And they wouldn't have to change venue, and it would be more expensive for Hambly. If I were Loader, I would have hired counsel in Indiana, not in Wisconsin. But maybe that's the case. Maybe maybe it's like a combination. He's got some connection to this attorney or a personal recommendation. And also they want to move venue to reduce costs. That's the only thing that makes any sense to me in this move. But that's where we are. So what I will speculate has happened. I will speculate that they have requested an extension on their time to answer the summons because the summons has been issued. And I believe they're long past that. I'm guessing they requested an extension while they discuss proper venue for the case. Because if they're both going to agree that Wisconsin's a proper venue and is a more convenient forum, they can do that. Again, they'll still apply Indiana law, but it could reduce costs for both of them at that point. And if that's beneficial, well, I don't know if it would reduce Hambly's costs because he hired Bill Simmons or whatever, and I don't think that guy's located in Wisconsin. I think he's located in Texas. So, but either way, it would reduce Loader's costs. So maybe that's what he's after. Bagel Goose says, within the law, McCaw is on the case. How dare you, sir? Landoname says, me, you, Cody, and your friend. Sounds fun. DM me his name, please, on Twitter. This is going to be so fun. Thank you, Nick, so much. Enjoy your vacay, buddy. I will. I am going to enjoy this vacation so hard that it's sad. John Penn says, plan to avoid being arrested at civil court for assault and battery. That could be the case. But based on Hambly's injuries, I think, and his statements, I think it's a felony assault anyway, and he could be extradited without any issue in this case. So I don't know if maybe it's part of it, but I think he could be extradited. That's a good thought, though. Siren Jag, maybe he thinks he'll bleed Jeremy out of money by making him hire new lawyers for Wisconsin. He wouldn't have to. His lawyer would be waived in as pro hoc vice in Wisconsin. No problem. Steph 1 Rip Sargon's Patreon, Chatelet to his income. So that's where we are. That's where we are in the quartering, quarter pounder, quarter pounded, whatever you want to call him. Beaten up by a pony, a magic unicorn or whatever, an unabashed brony. Like, I don't understand any of these people. Okay. So who knows? Who knows? But that's where we are in these cases. So that's where we are on Diversity in Comics. That's where we are on Hambly versus Loader. That's where we are on Greer versus Taylor Swift. And that's about all the stuff I had set up for today. In full disclosure, I spent today trying to lock down 2 interviews for tonight. One of them was not possible due to logistics. The other one, and I'm not going to mention that person because there's, I asked them on short notice and they were unable to do so. The other one, I'm trying to get the person who claims to be the former business partner of Mindy Wheeler, who, as you know, is involved in a severe amount of I'm going to say self-imposed drama with Comicsgate because Mindy Wheeler had the opportunity to just say her piece and then move on, but has been dragging out that process for quite some time. So the former business partner, allegedly, of Mindy Wheeler and her husband reached out to me and said they did not appreciate what she said about them on the stream and wanted to speak the truth. I have invited them onto my show. I will do my best to vet this person to get some proof. I don't know if they're legit. They won't respond to my messages now. So, or haven't. I shouldn't say they won't. They have not responded to my messages at this point. They are welcome on my show so long as they can provide me some evidence that this isn't just a long con troll job. But I'm happy to provide an alternative viewpoint to things that are discussed on this show. So that was that fell through tonight. I was hoping to get that, and I thought that would make a great interview, but we don't. We were unable to connect. And so I decided to do this update stream. And then, of course, Sargon gets kicked off of Patreon right as I'm starting up. And that is huge news. So what's the verdict on that? Should I create a poll over on StreamMe? Sargon kicked off Patreon. Poll answers. Sargoy deserved it, or Akkad did nothing wrong. Okay, we're not going to do a 60-minute poll. We'll do a 2-minute poll. So if you're on stream.me, there's a cool function that YouTube doesn't have, and it's the ability to create live polls. So I have created a poll on stream.me. Please cast your vote. If you're on the YouTubes, you are welcome to start viewing these things on stream.me. You can still do justice chats from stream.me. So if you want to, I will have no problem if people want to start migrating their live viewership over to stream.me. Or watch both or whatever so they can participate in polls and stuff like that. They have some really cool features over there. And the plan, this seems to be going well once I got Streamlabs fixed. The plan will be to simulcast on StreamMe and YouTube for all of this stuff. And then there will be some StreamMe exclusive videos, particularly covering really violent subjects with sexuality, sexual material in criminal cases, like if we're talking about pedos and stuff like that, because YouTube demonetizes videos that are critical of pedos, because YouTube is pro-pedo. We'll put that out there. YouTube is also anti-black. So I guess if I ever have a black person on the show again, I have to do that on Stream Me because black people get demonetized on YouTube. Yes, Keck7 Go. Third option is Denver versus Georgia. I will eventually read through Denver versus Georgia on Stream Me, I think. I have to verify that I can read through it. That type of stuff will all happen exclusively on Stream Me. And the favorite thing that I really want to happen is I want to have very contentious debates, and either mediation or just absolute slug down debates on stream.me, and those will all be announced as I get them arranged. If you guys know some people who need to fight it out in a virtual space with a moderator but want the ability to say literally whatever they want, I will host them on stream.me. Okay? So, the results of the poll are in. Sargoy deserved it. Got 11 votes, and Akkad did nothing wrong has 9. So it's a very close issue, as you can tell. Personally, I am opposed to any deplatforming. I'm just not, no matter who they are, what they want. If Antifa wants to have a Patreon and get all sorts of money from it, I'm okay with that, even though I'm completely opposed to Antifa's politics and their practices. They're the opposite of me in almost every way I can think of. Like they're virgins, they're weak. I don't know. But I would never ask for them to be deplatformed. I want everyone to say what they want. I want the worst racist and the best racist to have a platform. I want the least racist person to have a platform, and I want the most racist person to have a platform. I want all of it. I want everybody to be able to speak. And I want everybody to be able to generate income based on their personality and their words. So I don't ever want that. But that's me. I understand why a lot of people are happy that Sargon is off of Patreon. And like I get it. I just don't want anybody off of it. So on principle, I support everybody to make money. I'm so capitalist that I just want everybody to make money. Bagel Goose says his income is being shadowed. Well, would we say that Kekistan is choking off Sargon's income? Would that be appropriate? Would they be strangling his ability to make ends meet, or Pacole, why did you say Greer should go to Greenland? It's a sort of inside joke from the Dick Show. I don't know if it originated on the Dick Show, but the joke is statistically Greenland has the highest suicide rate. So I hate explaining jokes or whatever, but the joke is that he should go to Greenland and statistically maybe he'll end himself. I actually don't want Russell Greer to kill himself. It is entirely a joke. I think losing him to seppuku by idiocy would be a sad day for the internet. So there we go. My ADHD is in full effect. Got postmortem, Rekieta Law on both YouTube and Stream Me going in separate monitors. Read your justice chat, or did you miss it? Nope, you did. You did do that. You did not miss it. Sorry, you did not miss it. I missed it. Thank you for reminding me. Ryan English. Ryan English says, I hope you read my book before you get addicted to anime. I got here first with the crappy recommendations. Yes. I'm not going to get addicted to anime. I don't have time to be addicted to anime. I barely watch anything at all. Guys, if I'm not lawyering, I'm watching kids. If I'm not watching kids, I'm doing YouTube. That's it. That's my life right now. So, did I hear about pastor arrested at Mall of America? No, I did not. Landana May says, I'm in Indiana working with 90% blacks. Why be racist? You're in Indiana. Well, did you did you beat up Jeremy Hambly? No, I'm just kidding. Just kidding. I don't know. I'd like to be brutally honest, to be 1,000% as honest as I can be. Okay? On the race issue. I grew up in not the best neighborhood in Houston, Texas for the first part of my life. We were next to one of the top 5 crime neighborhoods in the city of Houston. There were murders, crack busts, and everything every day. I went to school right next to it. It was terrifying. We had all sorts of stuff stolen from us, and that neighborhood was almost exclusively black. But that also means that the kids that I grew up with were almost exclusively black. I didn't ever care about race. I was raised in a multiracial environment. Never bothered me. That's me. I don't care about anybody's skin color. I honestly don't have any sort of ethno tendencies. However, what I will say is I certainly understand the perspective of people who have bad perceptions of other races. But what I mean by bad is, for example, someone I know is a prison guard, and the black population of prisons, even in Minnesota, are massively higher than other demographics. All sorts of reasons we could discuss on that, not really important. The reality, though, is that this person's experience with black men involves criminals, largely. And so their perspective of black people is that they are criminals. That's the experience that they have. And so sometimes they have what people would consider a racist thought. Now, do I think that this person hates black people? Not at all. Not at all. I don't ever want to impose my beliefs on someone else, even when I find their beliefs to be wrong or adverse to mine or even absolutely abhorrent. It's not my job. It's not my job to do that. It's not my job to try and change someone's mind or fix them, because I don't think that we can objectively make claims about this stuff. And you can't speak to someone's experience, and you can't speak to what data they've reviewed and what conclusions they've drawn. You can only voice your own opinion. So the interesting thing that I will say is that I have been able to get along with racists just fine, I guess because I'm not whatever race they don't like, but I'm not able to get along with people who are vehemently opposed to racism, typically, because they can't take a joke or an alternative opinion. So, yeah, I don't know. I don't know why people will be racist or not racist. Both of those are confusing to me. What goes into what makes people's minds is something. It's too much information for us to just determine how those decisions are made. So I don't care what people's perspectives are. I will always be open about mine. That's all I can do. And I will talk to anybody. I will talk to people who want to genocide every race, any race. I don't care. Will talk to absolute pacifists, because I think the exchange of ideas is the most important part. So there you go. Engines for Trump says Rackets was the one white kid in the hood. Dude, not even joking. My school bus got pulled over by the cops because 2 black kids from the apartment. I would have been in first grade at the time, I think. Yeah, I was either kindergarten or first grade. I believe it was first grade that I started riding the bus. It was one of my first times on the bus. And these kids were in 4th grade, and they were big, and they were throwing bombs at each other. I was terrified, and we had assigned seats on that bus. So here I am, like the scrawniest, littlest white kid ever, sitting there while these big black kids were fighting on the school bus, and we got pulled over. The school bus driver called the cops right on his little radio, and this old white cop came on and was bashing the seats with a nightstick. Burned into my memory. Terrified the heck out of me. This poor little kid driving through the hood. And if you want to know where I grew up, in Houston, if you know anything about it, I would have gone to Eisenhower High School had I stayed in Houston. I may be dead at this point because I'm kind of sarcastic. And it was not the best environment. I grew up in a place next to Acres Homes. Acres Homes back in the 80s was very, very violent. So, yeah, I mean, that's it. I don't have any street cred or anything like that. So we moved away when I was about 10, and then we moved to 98.9% white Minnesota. So wildly different environments. It was great. Good times. But let's see. Keck7 Go says, play date tomorrow. I have a plan on doing some Total War Warhammer 2 with another fine lawsplaining Discord member. Maybe. Also, when I get back from my vacation, me and I keep calling him my thumbnail guy, but he's more than that. I don't want to call him a producer, but he's my channel advisor. He and I are going to potentially start seasonal characters on Diablo 3 for the next season. So we might want to, if anybody's interested in that could be fun too. Let's see. Rip alternate reality rackets. Yeah, he died. He died in high school. Brennan Pitt says, even the best part of Houston are less than a mile from a ghetto. Absolutely true. Absolutely true. You can be like driving down, Memorial. You can be driving down Memorial, go past $1 million homes. You go a quarter mile away and all the homes are on blocks and all the Cadillacs in the driveway have rims that reach into other lanes. I unironically love Houston. I hate driving in Houston, but I love it. I love the chaos of that city, and I love the donuts of that city. So, all right, guys. Well, I think we should probably wrap this up. Because I can just sit here and yak with you guys all day. I'm happy to do that, but I don't have any more topics to cover. So if there's something anybody wants me to cover in the chat, please drop it, and I can talk about it briefly. Otherwise, I should probably end the stream, go to the bathroom. Maybe I should stream on Twitch. I haven't done that in a long time. Landoname says, holy balls, does Keck7 like anime? Landoname, buddy, you should join the Discord. You should join the Discord. There's a new Path of Exile expansion in a few hours. Get that instead. I tried playing Path of Exile, and I think I was in a bad mood, but I just couldn't play it. I just couldn't get into it. I've also got Wolzen, and I want to play that, but I hate alphas that revert back. Or it's in a beta phase, and it's going to revert back to the alpha at some point soon. I want that game to just come out because I'd like to play it. I think it'll be fun. Play some Super Smash Brothers Ultimate. I don't have it yet. Random American, we don't know why specifically Sargon got kicked. Apparently on the Ralph Retort, there was some speculation that it was because he gave a speech to the Proud Boys, which is weird that would do anything. But I don't know, maybe in the speech he said something Patreon didn't like. Or, I know, why don't you just build your own Patreon and build your own payment processor to support it? Because the decision may not have come from Patreon. It may have come from Stripe. It may have come from MasterCard. That's the reality of the situation we're in, where the payment processors hold sway over platforms, and that's wrong. It's wrong. It's wrong. Just build your own internet. Yes, thank you, Rapey. Alembi says, what has you interested in the next season of Diablo 3? Nothing specific. Just the fact that a buddy of mine is going to play it. And I love and hate playing Diablo 3. I really like it at first. Getting a seasonal character, getting to like 700, 800 Paragon is fun. And then after that, it starts to die off because I can't play it like 19 hours a day. But I like playing through the season and just getting a character and running some rifts and stuff like that. I find that entertaining for a while. It's a good click fest. But the E is silent. Okay, so it's just rape. Okay, so Tumiki for you says they probably suspect that because Milo was kicked off Patreon because of affiliation with the Proud Boys. Well, there you go. It's a good reason. How's your father? Did you discuss the legality of certain kinds of anime on your anime stream? If you're talking about lolly is legal in the United States. What I understand is it may not be legal in Canada and the UK, depending on the circumstances of the lolly. It's legal in the United States. So Gab is wrong, by the way. Andrew Torba, another guy who has not responded to me, although, he probably gets a lot of communication. Andrew Torba is wrong on his citations on federal law when he says that anime or that lolly is illegal. It is not illegal in the United States. It would take a lot of very specific circumstances for lolly to become, or for a particular type of lolicon to be illegal in the United States. They would have to be identifiable. It would have to be virtually indistinguishable from a photo of the identifiable minor for it to happen. Just a representation of a minor that you can identify is not likely illegal. The section that he was citing actually covers the digital representation of a photo. Because Congress doesn't know how to really word that appropriately. It's like the literal bits or the arrangement of magnets on a hard disk plate that represent an actual photograph. So we're not talking about digital image that looks like a photo and is identifiable in the sense that I could draw a picture of a child that could be identified. That's not the same thing. They're talking about photorealism, and specifically probably a photo. Because I think even a photorealistic painting of like Barron Trump getting plowed by Hillary Clinton, for example, might actually be legal. Even if you could clearly identify it as Barron Trump, even if it was photorealistic, and even if it was plausible, because I think Hillary might actually try to do that with her man penis. If all of those things were true, a painting of it that you could demonstrate was a painting and not a photo might actually still be legal. That'd be the closest question you could get. But with the law that Torba was citing is covering the actual like film that a picture may be stored on, or the digital media that it may be stored on, like a flash drive or a hard disk plate or any other type of media that could reproduce a photo or a photo image. That's what they're talking about. So, yeah, I hope that helps. There you go. So that's so lolly. No, we'll probably discuss that a little more. Heavy Fisted said, thoughts on for-profit colleges since Virginia College is closing its doors. I think all colleges should be for-profit. I don't understand the purpose of a not-for-profit college. I barely understand the purpose of a not-for-profit entity at all, because I think that profit is the motivator. And non-profit entities don't make profit for the entity, but they make profit for the people involved. I think nonprofit is a misnomer, and it's a marketing tactic, in all honesty. But if you're a company that is not trying to increase its revenue and then put that towards growth and put that towards paying your people, I don't know why you're in business in the first place. So a nonprofit college doesn't make sense to me. Edamame Boy Akasit says, check out bitbacker.io if you're looking for a Patreon replacement with Bitcoin support. Also saw 4 streams started on my subscription tab. Boomer alert. That's only mostly my fault. The first stream was going fine, except for my Streamlabs actually froze frame the image. It was broadcasting just a frozen image to both YouTube and then to StreamMe. And then I found out that when I ended the stream on Streamlabs, it actually, the restream ended the YouTube stream on YouTube. So I couldn't just reconnect to it. So sorry about that. But now that I know how it works, we shouldn't have that problem in the future, which means we're definitely going to have that problem in the future. But there you go. Oh, and by the way, I just talked about the legality of lolly. It's still degenerate. But you guys know that. You guys know that. Even people who like lolly know it's degenerate. So I guess that's okay. But yeah, my thoughts on for-profit colleges are all colleges should be for-profit. They should ditch their administrative staffs largely because that's what's driving up the cost. They should also ditch, some of these required classes for degrees that don't make sense. And they should focus. What they've done is they've taken requirements and then they've jacked up price and they've said, well, you have to take this many credits, including these credits that are unuseful to you. And so they've bloated their product instead of maximizing profit from their product by narrowly tailoring the product to serve the needs of the client base. They've determined all this other stuff that their clients need to do to try and tack on. Well, with that comes increased bloat because the more people you hire, the more administrators you need and stuff like that. The more students you're accepting across broader things, the more administration you need. And administration costs rapidly increase the price of schooling. Also, you need to then further increase your infrastructure to the college. You need to increase the available housing, the available amenities. All of that stuff comes with increased costs, and none of it is necessary, right? If college focused down their majors into things that people actually wanted to take and were profitable in the long run, they could actually make money by charging less, by having less overhead required to be passed through to their customers. That's how other businesses do things. Colleges are just riding the wave of employers and common thought stating that people need a 4-year degree to be employable, which you don't. You don't need a 4-year degree to be employable, generally speaking. There are specific jobs where you do, but lots of very successful people, especially in the age of the internet, have succeeded without a 4-year degree. And the 4-year degree largely does nothing for your actual skill level. It's just a piece of paper that is a benchmark or a hurdle that employers look for. So that, I think, illusion is going to be shattered over the next several years as the sort of pendulum swings the other way. And the counterculture says that college is not necessary to create skilled workers. And we have guys like Mike Rowe pushing internships and apprenticeships and stuff like that. I think that might push back against that. But for now, colleges are riding hard on that. I think we're seeing the results, though, where colleges are unable to sustain unless they reduce standards and accept more people in. And when they accept more people in, they put out garbage graduates. That's, how I graduated or whatever. And as they produce garbage graduates that can't get hired anywhere, their college's reputation is going to go down. It's a long game back and forth, but the pendulum will swing against them. Are trade schools scams? I don't think so. Not at all. They're exactly what I'm talking about. You're focusing education into places that are specifically tailored for a narrow line of work. The only way it would be a scam is if they sell you on the availability of jobs in a given trade field. And they lie about it. Other than that, no, trade schools are fantastically effective, and trades are very high paying jobs. Like they get kind of dumped on by by liberal arts majors, right? Like myself. I have a liberal arts degree and an advanced degree in law. Compete with me intellectually, you plebeians. No, you get a plumber in here and he will talk circles around me and anything having to do with water, right? I'm just a dumb guy who got a degree in writing because I didn't want to do anything else, and then later in life decided to get a law degree because degrees in writing don't pay bills. But you get a tradesman in here. They can talk circles around me on any number of issues. There's nothing. They're specialized, right? And their education in that specialty is far beyond what any generalist would get on their generalist education. That's not to say that they couldn't, further their own knowledge, but a liberal arts degree won't teach you anything practical, like how to fix a toilet or how to replace a sink or how to build a wall and sheetrock it. These things are actually really important for an overwhelming number of people who don't know how to do it. And the joys of being a homeowner, right, is having to fix these sort of things and not knowing at all how to do it because you went to a college that was more important. Like for me, one of my classes made me write a paper on the history of ditch dredging in Murray County in the 1800s in Murray County, Minnesota. What the hell do I need to know about ditch dredging in the 1800s in Murray County, Minnesota? This doesn't matter to me. That doesn't help me fix anything. It doesn't help me own a home. It doesn't help me do a job. It doesn't help anything. But it was a required course at my college for no reason. What good did that do me? None. So there you go. Build the wall. You can't build a wall. You can't build the wall or any wall with a liberal arts degree. No, you have to get carpentry or masonry involved. That's the nefarious plan. Ben Cheever says, got here late. Happy for updates. Crazy what happened to Sargon. Really want to know how somebody can be sure that somebody like Wade discloses everything he's supposed to. Who would know if Wade hid evidence? He seems rat-like to me. Okay. Let me quickly talk about Wade. And let me talk about legal strategy in instances like this. We don't know what Meyer knows about Mark Wade and about Antarctic Press and about their interaction, right? We don't know. We got a brief hint of it in Meyer's video that he took down, where he kind of discussed, he was promoting his GoFundMe, right? And he promoted the GoFundMe and he talked about, for once, he talked about the lawsuit. He took it down like 2 hours after he posted it. But in that, we got some interesting details. I don't remember all of them, but we don't know what information Meyer has. What I can tell you as me, just a guy who's covered the case on a public platform with a much smaller audience than anything Richard Meyer has, right? He's got 90,000 subscribers. I've got 14,000, by the way, trying to get to 15,000. And I will have my friend Drexel back on, and we will talk all about him cucking people and that stuff, which is great. And fat chicks, whatever. We don't know, however, what information has been given to Meyer from people inside the industry, from people with knowledge of the case, from people connected to any of the parties. I can tell you that I get information about this case that I can't release and disclose, or won't release and disclose, from people who know, who have reason to know some of the interesting stuff. And I'm very interested to see that stuff come out. I will not report on it until it's public because I'm not going to compromise anything. But what I will say is how we will know if Wade is telling the truth is based partly on the information that Meyer may have about what Wade has done or said to other people that has passed through some sort of chain of communication and gotten into the hands of Meyer's attorney. Okay? That's how you find this stuff. Also, When people get under oath and they know that someone else with the same information is under oath, weird things happen in their brain, and even liars will start to tell the truth. Wade will know that the CEOs, the chief officers, or whatever their titles are, of Antarctic Press are also going, they're also going to give depositions under oath. What Wade says comes into conflict with what those guys say. Who's going to be more credible? The non-party or the person with something to lose? That's going to be running through Wade's head. He may be tempted to lie in deposition. He may be tempted to lie in an interrogatory. However, subpoenas to those to Antarctic Press and depositions of the two chief officers of Antarctic Press, that's going to provide a counter narrative to Wade's lies, potential lies, that might persuade him to tell the truth. So there you go. John Penn says that was meant to teach you how to do research. No, you're actually wrong, John Penn, and I'll tell you why. Because insider information on that class, he's talking about the ditches of Murray County or whatever. The research involved was buying the book written by the professor about the ditches of Murray County. So it was research on his book that he wrote and was selling to his students. That guy, by the way, can eat all of the peni in the world. Cave says, is the problem then the accreditation commissions? Yeah, in some way. John Penn says, university do not make money from the students. They make it from the research grant programs and other programs. That's for research universities, yeah. For like smaller universities, of course, a lot of private universities are research universities. There you go. Okay. Siren Jag says, ask me how many times I've needed history or physics or origins of world civilization after pharmacy school. In the meantime, I had to fight for the overrides to be able to take the course to sing in the university's choral. Well, how many times is it, Siren? I'm guessing it's few. I did really enjoy physics, by the way. Keck7Go says, mother of drunk driver gets thrown in jail in contempt for laughing at the family who lost a loved one, so better not laugh in court. No, never laugh at a victim in court. Don't do that. Don't do that. All right, guys. All right. Thank you, by the way, for joining this stream. I think I'm going to wrap it up now. I hope the restream worked. I don't know. I think they put their watermark on my video. They're supposed to, but I don't see one on YouTube, so I don't know what that even looks like. So who knows? Who knows? Maybe I don't think they did it on Stream Me either. I need to figure out how to get the Stream Me notifications, like, because there's emotes and pictures and stuff happening on the display that I don't know how to get onto the show, but I'll do that. I'll figure out what I can and better integrate this as we go on. This was really a test run of it, so thank you for doing that. Yeah, I don't see a watermark either, but they have a subscription service that allows you to remove their branding, which is weird because there is no branding that I can see. I don't know. I don't care. I'm not going to argue with it. Maybe the branding comes after like a free trial that I'm not aware of. Anyways, thank you guys so much for joining me. Thank you so much for participating in the stream, of course. Thank you, of course, for the super chats and justice chats. They're wildly appreciated. And thank you for all of the emote stuff that's going on Stream Me. And look forward to more in the future, I suppose. Hopefully you enjoy this stuff. And tomorrow's stream may or may not happen. I will update it on Twitter. Please follow me on Twitter for updates. Originally, I was going to have Cecil and Yellow Flash. We're going to drink whiskey and we're going to make fun of people and just have a fun conversation. That's the idea for tomorrow's stream. A chill mock stream or whatever you want to call it. I don't know. However, I'm a bonehead and screwed that up and scheduled it while I might still be driving in preparation for my vacation. So it may be late. It may not happen. I have to confirm one thing, which I can't confirm until tomorrow. Oh, excuse me. I will announce on Twitter whether or not that's happening. So there's that. And then after Friday, I will probably not be streaming for about a week. So probably not till the following Monday, streaming will resume. What is the date on that? Let me check the dates. Monday's the 17th. A stream on Monday is iffy. A stream on the 18th is going to happen for sure. That will happen. But yeah, so I may record a brief video and release it, but it will be very hard for me to do so from where I will be. So thank you again, and I will see you guys all on the 18th, if not sooner, of December, and I will be older at that point, and everything will be grand. So you guys all have a great day. When are lawyers ever not on vacation? I feel like I've been on vacation all the time right now, but it's this time of year. Having a lot of kids and having family in different parts of the country means we travel Thanksgiving and Christmas. It's just part of it. So that's how it goes. But anyways, guys, thank you so much for joining me. I'm going to blank out the stream. As soon as I see it go blank, we'll end it. And then it'll end everywhere else. So you guys have a good night. Peace.